Dear participants, dear friends, we are happy to welcome you at this 14th Global Digital Encounter dedicated to a real topic of the future, expanding business thanks to data economy and how IP can be a tool for expanding business thanks to the data economy. Both the FIDE Foundation and the Transatlantic IP Academy have pooled their forces in these global digital encounters. Now it is our 14th one, and the big objective of our encounter is really to reimagine IP, to understand the new challenges that the intellectual property system faces on many aspects today on in the field of data. In the field of data, more specifically, we are much interested to see how IP can be a tool in the new data economy, in particular in science, business, education connected to data economy. How can patents, including scientific publications that may be connected to patents, may be used as source of data for monitoring development of technology, using AI-based methods, and so on. So this is, we have a very large agenda for today, and we have a marvelous panel, if I may say, composed of prominent specialists who basically will enlighten us thanks to their worldwide experience. We have the honor to have with us Dominique Guélec, who is scientific advisor of the French Observatory of Science and Technology, was the chief economist of the European Patent Organization, held senior positions at the OECD, and is worldwide recognized as one of the best specialists of the economics of patents and of the interactions between patents and cutting-edge issues. We have with us Professor Guido Noto-Ladiega, who is Associate Professor of IP Law and Privacy at the University of Stirling, is active in promoting the culture of artificial intelligence, advises the European Commission in various committees, has been is the author of numerous publications on this very topic, and therefore represents really the growing power of academia in understanding artificial intelligence. To moderate the debate today, we have my friend Professor Aurelio Lopez Taruela Martinez from the University of Alicante, who's writing on artificial intelligence, on private international law, intellectual property, and cutting-edge technologies are really marking European and worldwide doctrine. And this is why we are really so happy to have all of you today to discuss between yourselves, and then also to enlighten our participants in the light of their questions in our chat. So this is really a very special moment for us. We are working in the spirit of the Global Digital Encounter for not for examining and reviewing past issues, but really for concentrating on the challenges of tomorrow. So our warm welcome to all of you. We thank our sponsors. This is a pro bono activity, but we have supporters and sponsors who generously give us their endorsement in disseminating information on the Global Digital Encounter. We have participants from 80 countries in the world following us, and we are really honored that you are again with us. Coordinator Javier Fernandez Laschetti will now also welcome you in this activity. On my behalf, as co-director of the encounters, I am really glad that in this month of July, we still have such a large audience for a key topic for our future. So, enhorabuenas, we can say in Spanish, for this encounter.
Thank you, Laurent, and welcome you all again to this encounter that is the last one before the summertime in August. And it's an interesting issue, you know. From a long time ago, business people has been looking for how to make money with data. Some of them achieved this philosopher's stone. Some others are still looking for this El Dorado. But we all are interested on how the data could create a new economy, and we have many examples, and we will have many examples in the future. So it's very good that we started. I think will be the first encounter about data, economy, money, etc. And I'm very pleased to have these participants and to have these panelists and my friend Aurelio Lopez Tarroya as moderator. So the floor is yours, Aurelio. Welcome you all, and remember, we belong to a community. You are part of the community. Thank you, and the floor is yours, Aurelio.
Thanks a lot, Javier. Thanks a lot, Guido, for Logan, for this kind invitation to moderate this global digital encounter. Let me congratulate you as well for the great job you are doing with the encounters. You are sharing a lot of knowledge and promoting the exchange of ideas that I consider is extremely important these days, and even more if it is in a global scale. And to moderate an encounter on data economy and IP is not an easy task, because even from a legal perspective, data can be approached from many different angles. To start with, many times I heard the speakers talking about data protection when actually they are referring to personal data, and they are not talking about the protection of personal data, but the protection of the data subject. While we will be briefly referring to this approach, actually in this encounter, we prefer to focus in data as a new intangible assets, as Javier and Logan has mentioned. A new intangible assets as the new oil or the new resource that makes AI system works. But even from this perspective, data is a diffuse concept. The new mantra of promoting data sharing and the creation of common European data spaces seems to refer to machine-generated data or industrial data. However, it should be recalled that many AI applications need to be trained with text, images, sounds, audiovisual recordings, and actually for a computer system, these contents are data as well. And for us, these are intellectual creations that can be eligible for protection under intellectual property. Presently, the European Commission has announced an evaluation on whether the API system is flexible enough to facilitate access to data. This is tantamount for European companies to be able to compete with companies in third countries, since, as the European Commission is constantly repeating, there is not enough data available in Europe. There are examples of measures to promote access to data, such as the directive on open data and the reuse of public sector information. And I would like to start the discussion with a good example of the use of public information for analytical purposes. And this is the case of patent information. And so I would like to start with Dominic, because he has a lot of experience on the new opportunities that the expanding availability of data and the increasing power of computer has for patent analytics. So please, Dominic, go ahead.
Thank you, Aurelio, and let me thank as well Laurent and Manuel, the Transatlantic Academy and La FIDE for allowing me to share with you a few thoughts this afternoon. Yes, definitely, I would like to talk about the opportunities that are opened by the availability of huge amounts of data, patent data. In fact, as you know, patents are based on a sort of social contract that includes a disclosure, a quid pro quo between disclosure of invention and exclusive right on the invention. But the fact is that with nearly 3 million priority applications every year, and with more than 100 million patent applications available at the moment in stock, this makes the word disclosure a bit void. I mean, looking for a specific invention is like looking for a needle in a haystack. And so it's the notion of disclosure could be easily sort of lost. Too much information kills information. That, I mean, is for humans. But if you have machines, then this sort of risk of losing information becomes an opportunity. With machines, you can exploit all these gold mines, these huge amounts of information, and that's what I will say a few words about in the next a few minutes. So using artificial intelligence for mapping technology developments. So humans can do it, but humans have done it for long, and they've done it with computers, in fact. They've essentially exploited so-called patent metadata, like the inventor, the assignee, the technology category, and so on, which are structured data and which have been for long quite easy to exploit for computers. But while doing that, you are missing the text, the figures, the formulae, and so on, which reflect the content of the invention. And the content of an invention, of course, is what is the most interesting in the invention. But fortunately, new techniques based on artificial intelligence, so-called natural language processing, allow to make sense of the text, hence to touch upon the actual content of the inventions. So these new techniques have been developed essentially over the past 8 to 10 years. There are names that you might have heard about, like Word2Vec, FastText, BERT, GPT. These are the main sort of software that are used for doing that. What do they do, these programs? Well, they transform text into vectors. And the good news about vectors, the good property is that you can manipulate a vector. A machine can manipulate a vector using algebra. And in fact, we'll see that this is much better than the traditional techniques like keyword searches that all patent attorneys have done, because with these vectors, these techniques, AI-based, they allow to capture the meaning of words, the meaning of sentences, and the meaning, to some extent, of the full document. For instance, you can identify synonyms, you can contextualize the meaning of words, and so on. So to give a few examples rapidly of the sort of uses that you can make of these techniques, well, if you compare vectors, you are comparing patterns, you can calculate distances. Hence, you can identify the technical neighbors to any patent. You can assess the technical differences between documents, and then you can do patent search. You can do also clustering of vectors, so clustering of patents, and you can then identify sort of the technical landscape, mapping technologies. You can position a specific patent, or you can position a company's patent portfolio vis-à-vis the current technology landscape, because patents can be added, so you can jump from an individual patent to a patent portfolio quite easily, quite mechanically in a way. So you can assess the freedom to operate and so on and so forth. But there is more than you can do with these techniques, and you can, in a way, do some forecasting. Look at the trends of technology in terms of words, in terms of keyword sentences, and so on. And then you can do more strategic landscaping, looking at what will be tomorrow's patent landscape, something that existing techniques cannot do. So I won't continue on that. There are many other users of this technique, like text generation, and you can write, you can generate text of your patent with these techniques and so on. You can even do some inventions, but that's a sort of different software that is to be used. We could talk of that. But overall, this is really a very enthusiastic development that are taking place. You can find a lot of resources on the internet, libraries with open source code. Millions of patents have been vectorized. You can find them, for instance, on the Google Cloud. You have patent databases like PatStat of the EPO that offer some text and so on. I will just conclude this very brief introduction by mentioning the current limits or the limits of the current techniques that not fully capture the syntax of text or very, very crudely, I would say. So the meaning of text is not always well reflected, not precisely enough. You cannot process figures and graphics at the moment, but there is a lot of research and there is very rapid progress in that. So I'm quite confident that it won't take that much time before they can do all that.
Thanks a lot, Dominic. I guess all this development are available or because the information is in open access. But in many times, many AI applications need to be developed or need to use information that might be protected by IP rights. This is what I was referring before, that the concept of data is very broad, and many times the data that we need to train AI applications or to make an analysis is protected by IP rights. And this is where I think the text and data mining exception that has been introduced by the European Union in the new directive is quite important. It should be quite important to facilitate research in these areas. However, in my opinion, the fact that the exception only has a mandatory character when beneficiaries are research and cultural heritage institutions, it's a problem. And it is my opinion that the use of this exception is not going to be as fruitful as it should be to foster innovation in Europe. I don't know what's your opinion about it. Guido, can you?
Yes, about the text and data mining exception.
Exactly.
Yeah.
I imagine since you are in the UK, you can make a comparison, correct?
Yes, and the UK actually has been the first country in Europe to introduce a text and data mining exception in 2014, so before the reform. So we've had quite a lot of experience and to some extent some success in the sense that there is data that shows that especially libraries have been using this exception to analyze large amounts of information. So there has been success, but there are also issues, and there are similar issues to the ones that you were mentioning about the sort of subjective element of this exception. The UK exception is even more narrow because it's specifically only about non-commercial research, whereas as far as I can understand, the European approach on this is slightly more broad, and also there are two different text and data mining exceptions. So there might be some room for maneuver there, and also if you compare the approach of the last directive, so the copyright in the digital single market, and the previous one, the InfoSoc directive, it seems to me that we actually, rather than progressing, we are we are regressing. Because in the InfoSoc directive, the non-commercial activity was defined with regards to the activity, not to the organizational structure. Whereas now, under the new directive, we look at the type of organization rather than the type of activity. Other very important issues, obviously we don't have a lot of time, but in the UK approach is that if you make a copy of some data and some content for text and data mining purposes, and you transfer that copy, to a member of your team, that amounts to copyright infringement. And obviously that's not how text and data mining work. So we need to have a broader exception. And I would go even forward, and that's the end. Recent work by Thomas Margoni and Martin Kretschmer is actually claiming that the type of activity that text and data mining does shouldn't even require a copyright exception, because it shouldn't be regarded as infringement to begin with. And I quite agree with that.
Yeah, I do as well. What do you think, Dominic? Any opinion on this issue?
Yeah, definitely. I think that there is a need for an exception that is as broad as possible. First, but second, there is a sort of technical barrier as well, because many of the valuable data sources are proprietary anyway, so they can't be accessed materially. Think of databases like Scopus or the Web of Science and so on. You need anyway to purchase the data. And then there are restrictions on the use that are contractual restrictions. So I'm not a legal scholar, but my notion is that there is little, the law is not making much vis-a-vis that. And it happens that when you want to do patent level technological landscaping, patent data are hugely important. But if you don't have access to, let's say, scientific publications, conference proceedings, and the like, in many scientific and technological.
Well, the point of contracts is actually very important, and that companies increasingly use contracts to essentially control data and access to data. And in theory, the text and data mining exception should prevail on contracts. But then in practice, if there is no serious public enforcement of these provisions, that they're not going to have any effect.
Yeah, that's an issue that would need to be solved. And actually, if we compare it with the situation in the InfoSoc directive with technical measures, the way it has been implemented in the member state is completely, I don't know, is just useless to say the less. Well, and another important aspect in this regard concerns the comparison with other jurisdictions, like for instance in the United States, where actually there is no discussion about whether data mining is allowed or not. Everybody agrees that is covered by the fair use doctrine, and we can see examples of the use of this exception with things like the GPT-3 by OpenAI, where they are basically using everything they find in the internet in order to train the AI tools. In my opinion, due to legal standards in one jurisdiction and the other, we are way far away in terms of innovation with other countries.
Absolutely. And this is due also to a very narrow interpretation of the three-step test. This idea that we cannot have a fair use in Europe, I think it's simply wrong. We can have it and we should have it.
Yeah. There is one last question that I would propose to you to discuss that concerns actually personal data. I was mentioning before that I did not want to go into personal data, but actually there is a topic which is quite interesting and in my opinion is unsolved, in the sense that we don't have a definitive answer. It concerns the interaction between intellectual property instruments and the GDPR, the General Data Protection Regulations, in the sense that many times we can find obstacles in order to comply with the transparency obligation in the GDPR without infringing IPRs. So what do you think about that? What's your opinion about the way this has been regulated so far in the European Union? Probably we can start with the GDPR, and then if we have time, we can discuss this proposal for a regulation on AI. But let's go first with the GDPR. Guido, what's your opinion in this regard?
Yeah, I would agree that this is an unresolved issue, and I think one that is going to be increasingly important, because you have, on the one hand, companies that are basing their business models on the control over data, including personal data. Now, is this control intellectual property? It's a gray area because partly it's controlled through trade secrets by simply keeping the control over these data secrets. Partly is the database right, the sui generis right. Partly it's simply factual and technical control over this data. So it is a gray area also in that sense. And there is a tension then with the GDPR rights, so the rights, in particular, the right to access the data that as data subjects in Europe we have. So how do you resolve the situation where companies claim that they have some form of ownership over that data, and at the same time users claim that they have a right at least to access this data, to have information about this data, etc. There's no definitive answer, but probably the starting point is a recital of the General Data Protection Regulation, recital 63, that says that that right, which means mainly the right to access, should not adversely affect the rights or freedoms of others, including trade secrets or intellectual property and copyright on software. Now, this provision, I know we only have 3 minutes to discuss this. This provision is actually very opaque. It's not entirely clear what that means. A first thing that, based on this provision and a comparison with the previous data protection directive, that we should underline is that that this regards only the right to access, not also the other data subject rights. So this, for instance, means that that a company has still a duty to inform the users about data processing, about this sort of data appropriation that they are doing. So whereas when it comes to granting access to that data, maybe there is a conversation that they can have, still they have to comply with the other data subjects rights. So there is a one point that must be clear. The other point is the focus on the relationship between the right to access in particular and the intellectual property rights on data. And the most important thing to remember here is that when we say the right to access, actually we mean 4 different types of rights. We mean a right to obtain information as to whether the personal data is processed, a right to obtain information about the purposes of processing, a right to access the data, and a right to obtain a free of charge copy of the data. My argument is that only the 4th of these rights that intellectual property rights prevail only on the 4th of these rights, whereas companies still have to comply with all the other access rights. And this is very important also technically, because companies need to have in place systems where they're able to allow people to access that data, even though the companies are treating that data as a form of intellectual property. So it's a very delicate balance that should be achieved, but I think it's a very important one and an important conversation that we should have.
Dominic, what do you think? This is actually related with this famous black box problem. I mean, it's so. What's your opinion, Dominic, from your perspective on this issue? Can you hear me?
Yeah, I can hear you, although the connection is not that great. Can you hear me?
Yeah. Yes, we do.
Can you hear me?
Hi, Dominic. If you're having connection issues, perhaps you could turn off
your
camera.
Okay, I would just like on this issue, I would just like to mention case of patients' data, which is key, especially, or always key, but especially in the current situation with the COVID and the like, access to patient data. I know of a number of AI startups in the field of health. They have to go to China and where they can access patient data much more easily than they can in Europe or in France or other European countries. This is really a problem that, the European Commission and the lawyers should be aware of. It's really bad for Europe that we have to go to these other countries. We know that there are specific conditions for access. Well, there is a market for this data in China. We know that the genetic conditions are not exactly the same across populations. So what you learn on Chinese data is not necessarily transferable on European populations, and so on and so forth. So there are clearly extremely excessive limitations to access to data in Europe if Europe is really willing to develop an AI industry.
Mm-hmm. Yeah. I will remind the participants that the attendees that you can formulate your questions in the chat whenever you want, and I will make the questions to our speakers. In the meanwhile, I'm gonna give you my opinion about the issue, that it's probably is not very well developed, but I think it has some point, and it's the fact that we have the European Commission that has issued these ethic guidelines talking about that trustworthy AI in Europe that needs to meet certain requirements, but then actually we don't have the tools, the regulatory tools, in order to facilitate that trustworthy AI. For instance, we don't have the tools when we find a biased AI application. Sometimes the bias comes from the data, the training data that is used. But actually, nowhere is mentioned that neither public authorities or third parties have a possibility to access that data that has been used in order to develop the AI application. So this is going a little bit farther to what the GDPR says. I'm not saying that you should have complete access and free access. No, you can meet certain conditions. You might need a closed environment with some measures, technical measures. You can have that. And actually, when I look at the proposal for an AI regulation, for me, it was a missed opportunity that they didn't introduce nothing in this sense. And again, I think it's a missed opportunity. I don't know what's your opinion about that.
Hmm? Yeah, absolutely. I agree. And I think the fact that in a way this AI Act, this proposed regulation, really tries to mimic a little bit the ethical guidelines on trustworthy AI. Probably that's one of the reasons why it's not working a lot, because an ethical guideline is one thing, a regulation should be another thing, and then I think there is a lot of confusion. I think the closest provision to what you were discussing probably is Article 64 of the AI Act that says that the market surveillance authorities shall be granted full access to the training, validation, and testing data sets used by the provider, and under certain conditions, they can also access the source code, which I think it's perhaps a positive step overall, but it's definitely incomplete because there are also other stakeholders that might have an interest in actually accessing this right. It shouldn't be something that is only specific for market surveillance authorities, because if we want to make sure that there is no bias, then obviously we cannot. It should be a distributed type of access, and that's not what we have now. Again, as you said, maybe with some sort of caution, etc., protected systems to access the data, but still we should have it, and we should reflect again on the role of IP in this, because if rights holders can prevent access to the training data sets, then these forms of licensing can lead to forms of curatorial bias. So as a rights holder, I decide you will have access to this data, not to this other data. And the end result is obviously bias. curatorial bias. So we need to think about also the negative effects that IP can have in these situations.
Mm-hmm. Very good. We have a question from the audience in the chat from Carlos. I can imagine who this Carlos is. I think the concept of data access goes beyond the access to the information as such, and also involves access to the technical infrastructure, enable data understood as machine-readable encoded information. In other words, the software, the syntactic perspective. Therefore, both data models and data format should also be open when we refer to open data. Some stakeholders might interpret this conception of openness as very invasive with regards to their protected technical future. So his question is, should open data also mean open software? If so, under which conditions, circumstances? What do you have to say about that, my dear Guido? And I don't know if we have Dominic somewhere.
Yeah, I think Dominic will have a lot to say, but I'm just going to be very brief here. I'm going to say hi to Carlos, who's done a lot of research on this, so probably he knows better than me. But again, the Article 64 refers to the possibility to access also the source code of the AI system if it's necessary to assess the conformity with the requirements for high-risk AI systems, and if there is a reasoned request. So there is a limited sort of recognition that when we talk about open data, to some extent, we need to have also open software. Now, open software can mean many different things, as Dominique probably will be able to tell us. So open software doesn't mean that it's a free ride for all. There are types of open software that are mixed or hybrid forms. So I think that the answer is yes. When we open data, we should actually also open software, but there are different types of open software. Dominique?
If I may intervene, sorry, I missed the connection was bad. I missed the question, but I could sort of interpret the question or infer the question from your response, Guido. So yeah, definitely opening software is always, nearly always a good thing, but in the case of machine learning, it's very specific. Because the software can be very short, but it's not really the software that has been used to learning is not the one that is actually making the inference and all the work in interpreting the data. And this software, so is learned by the machine, hence the word machine learning. And first, it can be extremely complex. GPT-3 is 170 billion parameters. So good luck to the European bureaucrats who will look at that and decide whether it's conform or not to the law. 170 billion parameters, okay, that are not interpretable by a human, by the way. Second, for most of these software, they use sort of random systems. So when you run the same machine learning system twice, you might not get the same result exactly. So your 170 billion parameters might differ the second time. So it makes little sense to do all that. Yeah, you should certainly have a number of standards regarding the fact that the data is not biased and so on and so forth. But if you put the bar too high, you simply kill innovation. And there are conditions that cannot be met simply by the technology in terms of satisfying certain legal standards, or you cannot check that they have been met.
Mm-hmm. I actually have a question.
So conclusion would be you should trust the innovators. And more than sort of looking at that more than from an opportunity perspective than a risk perspective. And if you think in terms of bias, there are biases with humans as well. And the difference between a bias with a human and a bias with a machine is that you can really look at the bias with the machine. You can sort of look for the origin of the bias, you can correct it and so on, which is not the case for biases by humans. And well, we could continue on that. There are many cases where machines have been shown to be less biased than humans. when it comes to selecting members of boards of directors, for instance. Humans are extremely biased. Machines are not. They look at the actual performance of candidates. So let's be cautious when it comes to that.
You're absolutely correct about that, Dominic. Guido, you wanted to add something.
Yeah, no, I wanted to ask something to Dominique based on your initial sort of question, because it made me think. The question was, you were talking about the use of AI to analyze patent data, and my question is about AI generated inventions. So as you know, and everybody knows, there have been 3 important cases last year saying that it's the Davos cases, saying that an AI generated invention essentially is not patentable because an AI is not an inventor. Now, those decisions, I think, created an immense risk. The risk is that people using AI to invent are gonna pretend and gonna conceal that the invention was invented by an AI, and then gonna say, well, I invented it. How is anybody going to find out? So my question is, can we have an AI as a form of verification of humanity? So analyzing patent applications, AI to analyze patent applications to discover whether that application, that invention comes from a human being or from an AI. Does my question make sense?
We have lost connection with France again, I'm afraid.
Okay. No problem. It can remain as an open question.
Again, yes, that will be an open answer as well, as I did not hear fully the question, but yes, about AI invention. First, it is progressing very fast, and that is really a key issue. It's progressing very fast. Quantum computers, which are combinatorial machines, that will even accelerate in the near future. So, and you're right, it's a sort of opportunity and threat to the patent system. If we take this angle to look at things, questions regard notably, so the identity. Can a machine be an inventor? The response from the EPO to date has been no. But, well, if there is a flood of inventions coming from machine, Europe and the EPO will be confronted with the question, do we want these inventions or not? So a time might come when we have little choice and to adapt again. Would be bad that we do it late. And second question regarding the patent standards, the notion of inventive step. I think, Guido, that you have certain ideas on that as well. I would be happy to hear them. But yeah, definitely, if you consider that a machine can be a sort of person skilled in the art, or a machine skilled in the art, that knows everything in all arts, that can combine things that are very remote, far away from each other and so on, you might then elevate the bar for patents, and the inventive step might become difficult to reach for humans. So there will be a need also of some reflection there. But Guido, you asked the question and you have answers as well, I'm sure.
But Dominic, let me ask you something from your answer. Are you opening the door in the future for granting patents to machines, or as a solution, or is that not the case?
Well,
this is a common question for both of you, actually.
Yeah, no, that's a very quick answer, and then Guido will give the long and best one. But my notion, I would have no problem with that, but I'm sure that what the issue is broader than that, because it is based on the legal status of machines. It makes little sense to grant a patent to a machine if a machine does not have a legal status as a person or an organization has nowadays. So it's a bigger legal question than just for patents and the personality, the legal personality of machine.
Yeah.
Well,
Guido, go ahead. Go ahead.
I'm absolutely against the notion that we should, first of all, recognize AI as having legal personality, and second of all, that we should grant patents for entirely AI-generated patent inventions, simply because there is the risk of overprotection and over-monopolization, because obviously an AI can invent very fast, and potentially, you know, if you think about it, could monopolize every possible sort of invention. Not every possible, but a lot of inventions in a certain field, thus blocking innovation. And this worries me tremendously, especially in the field, obviously, of healthcare. And you know, we've been discussing these days a lot about the negative effects of patents in the field of vaccines, and how sort of private corporations are prevailing on essentially the public interest. If you place that in the context of AI-generated vaccines, you can see what's the terrible risk that we face. We should at the same time recognize that increasingly we're going to have the use of AI to invent. So we need to assess whether we need to change the rules simply to prevent over-monopolization and to keep the right balance between public and private interest.
There is a very good comment by Javier in the chat concerning this issue. He says there is something to be considered, that is sufficiency of description. Isn't that a way to discover these false inventors?
Yeah, the sufficient, the requirement for sufficiency is obviously a very important one in patent law, because you are expected as an applicant to explain essentially how your invention works, so that the person skilled in the art can work out how the invention works. But especially in very complex field and highly technological fields, and AI is definitely one of them, sufficient disclosure is increasingly insufficient, in the sense that increasingly people that read the description cannot work out how the invention works, because you would have, for instance, you would need access to the training data, to the clinical trials, all these sorts of things that you don't really have access to. So sufficient disclosure nowadays in many fields is not providing sufficient transparency. That's my feeling. I don't know if Dominic agrees.
Yes, the notion of sufficiency of disclosure is broader than just for technology. It's also about science. And you see increasingly, including in mathematics, in chemistry, you see the question being raised when you have a discovery, new theorem or whatever, a demonstration of a theorem, a proof that is done by an AI that cannot be checked by humans. It will make an inventory of all cases or this sort of things, and humans can't check it. And the question is raised, should humans believe it? I don't have personally the answer, of course, but my notion is that there is a tendency for science and technology to become increasingly complex, and humans will have, if not to surrender, at least at some point to concede some, let's say, advantage to the machines. How we can do that while keeping control is an open issue, but we'll have to give some ground to machines, both in science and in technology. Giving ground meaning, let's say, trusting, believing results that are obtained or produced by machines that we don't understand. Mm-hmm. And of course, the notion of disclosure and transparency becomes, well, sort of fragilized in this context.
I see. Okay. Well, guys, I'm afraid that we have to close the discussion. Thanks very much for this time. I have enjoyed it a lot. I hope you have enjoyed it as well. And I just have to give the floor to Manuel to close this encounter. So please, Manuel.
Thanks, Aurelio. Good evening, everybody. So Aurelio, before moving further, let me ask you a very unusual question. our friend Ricardo Alberto Antequera, son of our beloved and legendary Professor Ricardo Antequera, wonders whether the mask you have on your back are related to the Diablos de Yare of Venezuela. Where do they come from? This has been a discussion, let's say, below the scenes about this very also very interesting issue. And then I will come back.
It's from Ecuador, Ricardo, I'm afraid, and the other one is from Mexico, and the last one from Vietnam. No one from Venezuela, but the time will come to have some from there.
So I guess the time will come, Aurelio. Good. I think we could agree that this has been a great and profound.
Your camera is off.
My camera is off?
Yes.
No, my camera is on. I can. No, well, I cannot do anything.
Perhaps try logging out and back again.
I will switch it on and then back again.
Now we can see you. Try disconnecting and coming back in again.
Or rather I will talk with you. You don't lose anything not seeing me, not watching me actually. Well, now you can see my perfect bowl, but nothing else. Yeah. It's quite interesting because I can see myself. I am the only one who can see myself. So anyway, let me go on. Yeah, just for 3-4 minutes more to conclude. I do believe that we had quite a valuable reflections. The issue is extraordinarily complex and controversial. Yeah, you were able just to open the Pandora box. You brought quite an amount of relevant questions on the table. By the way, many of these questions are recurring questions who also come out in other encounters before. But no doubt they will come back to pretty soon to other encounters. Yeah, if data is the oil of this new society, and we should not be scandalized while concluding, and I'm referring to the last questions, that the patent system was designed for a society. So the first and the second industrial revolution society, a society which does not exist anymore. So classic scenarios as business as usual or toilettage adaptation, they don't work anymore. And we should not scandalize ourselves or our people while trying to move to other much more challenging scenarios as disrupting scenarios or even reinventing scenarios. And this is what you have try to bring on the table today, and I do appreciate it. Dominic will remember our scenarios for the future work some 15 years ago at the EPO, and he knows what we are talking about. Yeah. We have to review the recording to learn more. Again and again, I'm convinced that it's extraordinary good to come to the encounter, but then we have to review the video in order to learn more. We have to read the report, which will come in some days, and we have to reflect also on this matter again. Yeah. So thank you for all those who have asked questions. Thanks to our speakers. Thanks to Dominic, Dominic, Guido. Congratulations to Professor Lopez Tarruella, who conducted in a magnificent way this encounter. 1 hour has passed so quick, yeah, but please recognize that you enjoy and this passed so quick, yeah. But above all, as always, many thanks to all of you who have been connected today. You are the protagonists of this growing encounters community. And as always, and I repeat again and again, I'd like to highlight the presence of our students from so many different countries. I would like to thank especially to our encounter support team. This time the report will be drafted by Javier López Guzmán, a Spaniard who is writing his doctoral thesis at the European Law Institute of the Free University of Brussels, and by Girish Magraj from India, who is just finishing his doctoral thesis at the University for Alicante and Strasbourg. They, as always, they are members of the Encounters Report team. Yeah. And also, as I always recall, if you are a doctor or a recent doctor and feel like joining the Encounters Report team or knowing someone who could potentially join, please let us know and we will enter immediately in contact with you. Each encounter is a world by itself, yeah, but all together form a splendid source of knowledge. There has been hundreds of interested persons who follow the encounters on a spot, but many, many more study them later, watching the recording of the different encounters, reading the references, reading the reports and the questions and answers. And we are very grateful to all of you. So, but this is not the end. Our 15th encounter comes next September 8th and comes with another topic as complex, as relevant as the topic we brought today on the table: intellectual property and private international law. As always, we will enjoy a top team of scholars. This time, the encounter will be moderated by Professor Pedro de Miguel Asencio from the University Complutense of Madrid in Spain, and the speakers will be Professor Marqueta Tremblay from the University of Nevada in the United States, Professor Toshiyuki Kono from Kyushu University in Japan, and Professor Axel Metzger from the Humboldt University of Berlin in Germany. These four relevant scholars are the main authors of an extraordinary relevant document, the last December 2020 International Law Association regulation on guidelines on intellectual property and private international law. And this is what we will discuss on September the 8th. So let me close this encounter. Very sorry if you cannot see me, but I'm closing. Let me close by thanking very warmly to all of you, to encourage you to read the report and to continue cooperating with the encounters. So take care, please. Take care. And come back in less than a couple of months. Yeah, do count of you for our next encounter, our 15th encounter. Please take note it in your agendas, September 8th, 2021. Enjoy the day. Bye-bye to all of you. Bye.